Welcome all. This is a presentation from Relate NGO, and this presentation will focus on the latest act enacted by Indian government, that is Mediation Act 2023. We'll talk about what is the salient features of this act and what is the importance and with respect to litigation processes, etc. And this presentation has been prepared by Relate NGO volunteers, and it is a legal awareness material. Let's get into the presentation. As I said, this is Mediation Act 2023. This was recently passed by the Parliament, and this came into effect from September 15, 2023. This largely talks about the dispute resolution procedures through mediation. So let's find out what is mediation. Mediation is a voluntary and a confidential dispute resolution process in which a third party, who is a neutral person, he helps the parties in the communication process, elucidating the issues and bringing out a collaborative approach to reach an amicable and an acceptable solution. So mediation empowers the parties to make their own decisions and is usually non-binding unless otherwise you have an agreement in place. So once an agreement is there, so it's a legally binding document. So basically, we hear about and another term called arbitration. So let's see what is the difference between mediation and arbitration. So mediation is something like, an as I said, is usually not legally binding, but arbitration would be legally binding. Would be a legally binding process. Um, so mediation largely focuses on the communication, collaboration, and consensus building, while arbitration is something like it's something related to court procedures happening outside the courtroom. There are very formal procedures followed there, such as evidences and etc. So this presentation will largely focus on the key features of the recently passed act and how this mediation can help in resolving the matters, avoiding lengthy court procedures. So let's see what are the key objectives of this act. The primary objective of this act is to promote mediation. So encourage parties involved in disputes to come together and resolve their conflicts. Enforcing mediated settlements. A crucial aspect of the act is providing mechanisms for enforcing the settlement agreements. So this ensures that the agreement reached between this mediation have a legal validity and can be enforced in a manner similar to court judgments. Yeah, and registration of mediators. So here mediators are professionals. They are registered, and the body is responsible for aggregating and maintaining a roster of qualified and experienced mediators, ensuring that mediation procedure is conducted in a very professional way. Encouraging community mediation. Another significant objective is to encourage community mediation. This means involving local communities involving in resolving disputes at grassroots levels. It recognizes that many disputes can be resolved more effectively within the community rather than through a formal legal process. And also it talks about the online mediation, given the rise of social media and other technologies which can help in avoiding transportation and effective time management. Let's see what is a mediation agreement. Writing the requirement to write a mediation agreement. The Act mandates that every mediation agreement should be in writing, and this requirement ensures that the terms of agreement are clear, documented, and are legally binding. Let's see what are the forms of written agreement. A mediation agreement can be of different forms. It can be executed as a standalone agreement specifically for mediation purposes, or as a clause within another agreement. So this mediation agreement would be a part of a bigger large contract or another agreement between two business parties or commercial entities. Pre-litigation mediation. Parties have the option to voluntarily refer their disputes to mediation before initial legal proceedings. This is a significant departure from the previous versions of the Act, and emphasizes that the Act's commitment to promote resolution over litigation. So it offers parties an opportunity to explore mediation as a means for dispute resolution. Let's see what are the exceptions and limitations under this Act. Let's see what are the matters unfit for mediation. So criminal offences and professional misconduct, disputes concerning tax matters. These are all some examples which which will not be unsuitable for mediation. These provisions are essentially to prevent the misuse of mediation in cases where there may not be appropriate, or there may be in certain cases that mediation may dilute the intensity of the offense. So the act lists out certain matters which are unsuitable for mediation, which is provided in the act itself. And ensuring proper application by outlining these exceptions, the act ensures that mediation is applied in all right contexts. It helps maintaining the integrity of the mediation process while recognizing its limitations in certain situations. Let's see how a mediator. There are provisions in the act which talks about how a mediator has to be selected. What are the eligibility for someone to become a mediator, etc. Particularly the mediator service provider. In cases where parties cannot agree on a mediator or the appointment procedure, the Act allows that the claiming party to seek assistance from a mediation service provider. This mechanism ensures that mediation can proceed even when parties are unable to reach a consensus. So this act would give rise to service providers who can engage in mediation or help in selection of mediators, etc. There are some provisions related to jurisdiction and venue. Let's see what is territorial jurisdiction. The Act specifies that the mediation must occur within the territorial jurisdiction of the competent court or tribunal responsible for adjudicating the dispute. This is essential for legal clarity and enforcement purposes. Parties have the option to agree to conduct mediation in different location or online. This flexibility is crucial, especially in a digital age. As I said before, in digital age, it is important and allows the parties to choose a mediation venue that suits the needs. Enforcement. Despite the flexibility in mediation venue, for the purpose of enforcement, challenge, and registration of mediated settlement agreements, the mediation is deemed to have occurred within the territorial jurisdiction of the respective court and tribunal. This ensures that the legal processes related to the mediation are clear and consistent. There is also another important feature of this act is the mediation proceedings under the act must be completed within a period of 120 days from the date of first appearance before the mediator, which may be extended for a maximum period of 60 days. So there is a time frame also the act provides. So with regards to delayed NGO, we can act as a legal counsel when you are facing any civil or criminal disputes, especially when you are interested to resolve the disputes in an amicable way without involving the court process. So we can help you to find the right mediators or third-party counsels who can act as a mediators, both formally and informally. And we have provided our helpline numbers as well as the link for online grievance reporting as well. So stay connected, and let's come back with another interesting material for as a part of our legal awareness material soon. Thank you very much.